have religious convictions. Do you think that is how the government wins this case?
I think that the Supreme Court certainly should rule that corporations like Hobby Lobby do not get the protections of religious free exercise, something that throughout our nation's history has been understood to protect living, breathing individual beings and not privately owned for-profit corporations like Hobby Lobby. That would be an entirely unprecedented step by the court.
For the next 3 months, that is, American Supreme Court justices will be touring Europe and other parts of the globe, delivering speeches and seeking to explain what they did and why they did it. But while they vacation, those decisions left behind from their 2014 session will be ringing in the ears and wallets of millions, with the words Hobby Lobby and union dues characterizing perhaps their greatest calls. What the judges decided, why, and the ramifications. Welcome into Midpoint, the former clerk for Chief Justice John Roberts and University of Missouri law professor Erin Hawley with the Insider's Take. Erin, thank you so much for joining us today.
Good to be with you. Thank you.
Erin, let's break this down first of all. Let's take the 5-4 decision by the court on the Hobby Lobby Conestoga case. Give us, if you will, the layman's look, exactly what happened today.
So it was really a good day for religious liberty and an interesting decision by Justice Alito, probably one of the more influential decisions he has written to date. And this case actually concerned a statutory question. So what the court did was say that the Religious Freedom and Restoration Act, which was a statute passed by bipartisan Congress, signed by President Bill Clinton in 1993, that this statute protects individuals who choose to do business as corporations, that these individuals may still raise First Amendment claims, religious liberty claims, as they do their business. So what the statute does is it says that Congress may not substantially burden an individual, or the statute defines it as a person, unless the government advances a compelling government interest and uses the least restrictive means. So in legal speak, this means that Congress has to satisfy strict scrutiny in order to burden the exercise of religion. The court's decision is remarkable in a number of respects. First, as the clip you just played suggested, the government pressed really hard on this argument that as a corporation, individuals are not allowed to exercise free speech or free religious rights through that corporate form. And the Supreme Court, again written by Justice Alito, said no, that's just not right. What the statute does is it defines persons to include corporations right in the text of the statute, and there's no indication that Congress intended anything different with the Religious Freedom and Restoration Act. In fact, that there's no argument that the Religious Freedom and Restoration Act applies to churches, which many are in the corporate form, or even to nonprofit corporations. So Justice Alito said, just because you as a business owner choose to take the corporate form, choose to make a profit, you don't have to leave your religious liberty rights behind. So it's a really big ruling here for both business owners and religious liberty.
All right, devil's advocate here. Is this or is this not opening the way then for a tremendous amount of legalese and also challenges and also interpretations? Because when you're dealing with religion and religious beliefs, you're dealing with a certain religion and certain beliefs and what people believe and how they believe it. That is a tentacle right there that opens itself up to so much as to what people believe is religious and what speaks to their religion. This seems to me as if this could literally open the door for millions of challenges if you went down the road into specific religions and what people believe, yes?
Yes and no. So under Supreme Court doctrine, the court is not allowed to sort of delve into the merits of a religious belief. However, you do have to show sincerity. So in this case, the court limited it, the actual opinion to closely held corporations. But both the Green family and the Conestoga family, the Hahn family, have in their corporate charters, in the way they conduct business, there's no question that they adhere to those religious beliefs. So that wasn't really an issue in this case. In future cases, although there may be some different religious claims raised, that there's a couple of sort of stopgaps in the statute. The first one being a compelling government interest. So even if someone has a sincere religious belief against, let's say, blood transfusions, the court could say, well, in this case, the state still has a compelling government interest, and they've proven that this is the least restrictive means that this person has to have a blood transfusion. And in that case, the burden would be met. And even though it might substantially burden a serious religious objection, the state could still go ahead and require that blood transfusion.
All right,
So
but
I think the burden analysis will apply differently in different cases, and still allow for the state to do some action.
all right, I want to focus on something you said in there. You used the word sincerity and measures of sincerity. Now, doesn't this mean that we are now going to have to get into what people feel and what they believe is sincere, what their religious beliefs are sincere? And again, this still is a tremendous gray area here, no matter how you look at it.
That's correct. And for that reason, the courts generally try to step back from that and say if there's objective evidence that the Hans or the Greens in this case were serious about the religion, then we're not really going to look too closely at that. We're just going to apply these other measures. We're going to see if there's a compelling government interest. We're going to see if there's other ways to go about doing what the government wants to do here. For example, in the Hobby Lobby case, in this contraception mandate case, the court said that there's no way it satisfies the RFRA test because the government has all sorts of other means by which to provide these 4 contraceptives that were at issue. The government could pay for them themselves. They could provide the sort of workaround that the government has provided to other nonprofits. Those sorts of ways of being least restrictive, another method of the government accomplishing its purposes here.
Isn't this either way, no matter what the government wants to say in the Supreme Court? They have always said that we don't want to get involved in personal religions, yet indeed they are right smack dab in the middle of personal religions now?
I would argue that this is an area where they actually need to be engaged. If they didn't take this step, and again, this is a statute. This is something that Congress said if it imposed this self-limiting principle on itself and said that if we as Congress are going to burden religion, then we're going to make sure we have a compelling government interest, and we're going to make sure it's the least restrictive means. So yes, that question does require the courts to decide whether there's a substantial burden on religion. So there is that inquiry. But otherwise, if there's not any inquiry, I fear that we would just allow religious liberty to kind of go to the wayside.
Few minutes we have left here. The second big decision today, Harris versus Quinn. This absolutely had the unions terrified before the Supreme Court handed down the decision here, because basically the unions are saying we're negotiating for everybody. If you're not a part of our union, which you're allowed to be by law in a right to work state, you still have to pay union dues to us. And we are at a time right now when unions are losing membership by the tens of thousands across the country right now. This is a huge blow, and a beginning blow, is it not, against union strength in this country?
I think that's exactly right. And it's also a big blow, or a big win, I should say, like Hobby Lobby, for individual freedom. In these cases, you have home health care workers who do not want to be part of a union and yet are required, or were required, to pay dues, raising all sorts of First Amendment issues, raising all sorts of other issues. And the Supreme Court said no. If you are not a union member, you cannot be compelled to pay for union activities. So yes, I think a big case here for unions and for individual freedom.
Where does this go from here now? Because obviously the unions are going to want to fight back. And remember, we have to keep in mind, too, that this is very simply about home care workers in Illinois who care for the disabled. So it's not as if it strikes against union power across the country. But does this not now indicate the beginning, and this will certainly go to a lot more states and a lot more unions and work its way right up eventually to the more powerful unions in the country?
I think that's exactly right. Again, yeah, this decision is limited to Illinois, limited to home health care workers in this particular union scenario. But I think we can see the writing on the wall, at least in a number of challenges now coming to members who are compelled to pay dues, even though that they don't wish to be part of the union. So I think that's right. This will be a big sort of opening salvo for individual freedom.
Was there anything we saw then, seeing as we've now basically seen the final 2 decisions by this Supreme Court, was there anything we saw in this court that truly, honestly, when you look at it from the decision, shocked everybody in what it happens? Certainly, perhaps some of the amounts of the decisions, but what shocked everybody here?
Oh, that's a good question. I think looking back, stepping back and looking at the term, one of the most surprising decisions was the 9-0 decision in Noel Canning. And in that case, a unanimous court disagreed with the administration and said that recess appointments that are very short, the president cannot use those time periods in which to make appointments and thus avoid the confirmation process that's required by the Constitution. So the unanimity in that case, on at least that narrow ground, was surprising.
Supreme Court's going to keep lawyers busy for the next 6 months or next 6 years looking over these decisions, won't they?
Absolutely.
It's welcome to another session for the Supreme Court, and now everybody really goes to work once the law of the land has been set. Hey, thank you very much for joining us today, Erin. We do appreciate it. We'll do it again.
Thank you.
All right, so there you have it. Hobby Lobby basically wins the contraceptive ruling in the Supreme Court today. It is a blow to the Obamacare provision, if you will, a 5-4 opinion written by Justice Samuel Alito, or Alito, I should say. And then in the other case, the Illinois case, it is again a 5-4 case. This is the union case, and again, this is